Hi, everybody. Welcome to January's webinar. My name is Sean Valentine, and I'm with my partner, Ryan Osborne. We are from Osborne Valentine Family Law and Mediation. We're here to talk about your key first steps for separation and divorce. We really appreciate everybody coming to join with us and have this conversation. We're really going to be having a conversation back and forth between Ryan and I about some of the things that we usually advise our clients on when they are thinking about taking those first steps and they've maybe contemplated separating from their spouse, whether a married spouse or a common law spouse. To be very candid with you, we got to make this joke, but we are the lawyers. But there, we have the disclaimer that we're not giving you out legal advice right now. This is just information for you to take forward and use and utilize to make the best decision possible for you and your family. But just to make sure again that you're aware that we are not giving you legal advice during this time. We are family lawyers. We do that 100% of the time. We are seeing people on the marriage cohabitation contract side, and we also see people on the separation and divorce side. We deal with married spouses and we deal with common law spouses. So we kind of live and breathe this every day. And really, the goal today is to talk about some of the things that you probably have been thinking about in terms of taking those first steps, and some of those things that you might be worried about, some of the fears that you might have, how to approach certain scenarios to get to those next steps so you feel comfortable and supported to take those first steps in terms of separation. And we're going to be talking about different processes and different things like that as well. To start off, we should always like to talk about the definition and criteria for what we call the date of separation, right? You kind of need to think about what day that will be and how that crystallizes and kind of the effect that that might have on you moving forward. So most of the time, people can agree on it because there's some type of current event or there's something that might have happened there where you say, okay, you know what, we are separating, we're kind of done. There's sometimes where it can be difficult. I mean, you're not really able to determine it because maybe you went back to counseling or, you know, there wasn't really an expression of it, but someone internally felt it and didn't express it to the other person. But that date of separation is important to figure out, mainly from a support perspective and then from a division of assets perspective. There's a lot of factors that the courts have utilized to determine what that date of separation is if there is conflict. I'm not going to go through those right now, but that is something important that we usually like to ask in our initial intake is, you know, what is your date of separation? So we can highlight that and make sure we're working with that date in mind to work towards the, you know, different rights and different obligations that you're going to have. That is different than your divorce date, right? So if you're married, a divorce always comes after separation. We have a lot of people who basically think or assume that you just separation and divorce come hand in hand, right? The separation date is when you no longer are a couple. You're no longer going to be maybe living together or doing things as a couple. Maybe you start to separate your finances, different things like that. Your divorce date is when the court grants you a divorce order and you can apply for a divorce certificate. Generally, that has to be at least 1 year after you separate before you can actually get granted that divorce. There are a few exceptions to that, but we're not going to get into that as well today. But you do need to understand the two differences between your date of separation and your date of divorce. And those are some of the things that we can also talk about as well. Now, I'm going to introduce Ryan as well, who hadn't even get to say a word yet, but he's going to come in and he's going to talk to you a little bit more about some of the first steps you can do in terms of getting yourself ready to articulate that separation or talk about it, or how you can prepare yourself best to move forward in that first stage.
Perfect. Thanks, Sean. I'm Ryan, the other person on the screen who's going to be chatting today. In that vein, I want to pick up on where Sean left off and throw out talk about two potentially fiery issues when it comes to the date of separation. Two things people fight over. They might fight over the date because there's financial incentive to do so. Maybe someone came into some money after a potential date of separation, and they want that money to be left out of any, argument or negotiation. Maybe the date of separation was a few years ago, and something called a limitation period could apply, which means you have a certain number of years to advance certain claims. in Ontario. The timelines are different depending on the situation and the relationship, but sometimes people will say, "Well, we've been separated too long, and you didn't make these claims, so you're out of time. You can't come after me anymore." So while the data separation typically, or more commonly, I suppose, is not contentious because there was a day in the therapist's office or a conversation that was had and everybody knows that was the day. Sometimes it's a little messier. Sometimes it's the date that you moved into separate bedrooms, but that's not definitive because lots of people who are married sleep in different bedrooms, or maybe it was the date you told your friends or family or whatever. So that date can be pretty important. So it's something to keep in mind when you're contemplating separation. We can't assume that just because in our own minds the relationship is over, that that's the case in the other person's minds or in the eyes of the law. So that's one of the key first steps that I'm going to talk about is firming up that date. Okay. Before I get into that too much, I want to say a quick word on safety planning. Divorce and separation is one of the most dangerous times for people um, in their lives. Okay, so if you have any concerns that the conversation might result in a dangerous level of conflict, there's something we can do called safety planning. There are professionals that engage in this. Lots of lawyers should be trained in how to identify these issues. And that just means making a plan for how to deliver the message that you want to separate safely. And it could just be a logistical thing. It could be making sure you're at the therapist's office where there's a third person present, or in public, or family members around, or something like that. Um, so I'm not going to go into too much detail on that, but it's certainly something to be mindful of, and I don't want to pretend it doesn't exist. So just be mindful that this is a dangerous time, and it could be worth getting some free advice on how to do this safely. Okay. So you've had the chat. You've you've said I'd like a divorce or a separation, or maybe you've sent the text message or whatever. We see it all. Um, what happens next? Okay. Likely everybody's feeling like they're in limbo and their world has been completely thrown into disarray. It's very difficult for us to coach people on how to deliver that message to the point, direct, respectful. That is all you can do, but we really can't. We have no idea how our partners are going to respond to these things. So being prepared for that is going to be important. But let's fast forward. You've agreed, or one of you has communicated that you'd like a separation. Well, what's next? What do we even think about? How do we move forward? Do we move out? Who pays for stuff, right? So the big things that Sean and I are walking through with people at the outset, either because they're contemplating separation, or they've just separated and someone gave them a lawyer's name, and that's us, for example, or they found us online. Um, Choosing the professionals that you work with to resolve the issues arising from your separation, and choosing the process that you go about resolving those issues within, I think are the two most significant decisions that you can make. Okay. Um, when I say process, I mean, are we going to sit down at the kitchen table and figure this out ourselves, write it down, divide it up, go on our way? Are we going to go to a mediator? Maybe that person is a lawyer, or maybe they have a social work background or some other background, and with some familiarity in the financial issues arising from separation. They'll guide our conversation for us. We're going to hire lawyers, and are those lawyers going to negotiate on our behalf with each other? What kind of lawyers are we going to hire? Do I want a shark who's going to yell and bang the table and take aggressive positions to try to get me the best possible financial deal I want? Or do we want a more collaborative type lawyer who's going to engage in discussions about goals and interests? What's really important to you here? What do you want? How can we find something that works for both of you so you can both move on? Okay. And at the far end of the spectrum is court. That's where you plead your best case to a judge or an arbitrator, which is like private court, and they make the decisions for you. They tell you how much money you're getting, where the kids are going to live, everything like that. So from the spectrum of making decisions ourselves all the way to having the decisions made for us. Court, you're signing up for a couple of years and probably tens of thousands of dollars of pain. If you have kids, they might get thrown in the middle of that. Might not be very much fun. Okay. You sit down at the kitchen table, might save some money, save some time, but maybe you don't, maybe you miss the fact that there's a big tax issue that that's going to follow one of you, and you didn't plan for that. Or maybe you said, "Oh, I'll keep the business and you keep the house," but you didn't know the business was worth 10 million bucks or $1 million or whatever, and the house was worth way less and had a giant mortgage on it. So these are the considerations. Right? How do we want to feel at the end of this? How do we want to work through these really difficult issues together? And who do we trust to get us through this process? And that's where I'll tell people who call me, I'm like, please speak to multiple lawyers. Find the person whose process resonates most with your goals and what you want, and the person that you trust the most, because we're going to be having hard conversations. I get yelled to, so not yelling at me, but they're yelling to me. And we work through tears and fears, and then I have to tell them how to divide their RRSP. It's a lot, okay? So the people you work with are going to make the difference between having a separation agreement in 6 to 12 months and a possibility at, a friendship with your kid's parent, a co-parent, or whatever you want, whoever they are, down the road, or acrimony and pain and time. So talk to a lot in short, talk to lots of people, find out about different process options, choose the people in the process that you trust the most. And when you do, you got to propose how you'd like to proceed with your partner. If you hire a lawyer and they suggest sending a letter to that person, my last piece of advice is just read the letter before they send it. A lot of lawyers don't realize that they speak, or I say we sometimes speak in ways that are pretty normal to us, but seem kind of confrontational and aggressive, or highfalutin to other people, and we don't want to put them off. So if you want to make sure that they know your goal is to be amicable and work through this together, make sure that tone is reflected in that lawyer's letter or whoever. So that'll be my final piece of advice on getting started once things are moving, and once you're in a process and you're working with some professionals. Sean will tell you a little bit about what that looks like.
Yeah, and the only thing I'll touch upon too is that lawyer letter that we traditionally send. You can tell us when you want that to be sent as well. We understand that timing can be difficult, or it can be a cause of stress or anxiety. So we want to plan that with when you're comfortable, right? And so if you feel like there's a situation, where you need to be out of the house or you need to be maybe at work or something like that, we can really work with you to make sure that you feel supported when that initial introduction goes out, because that's really what we want. We don't want to create conflict. We want to de-escalate it, and we want to make sure that we're moving you forward, but we're also doing it in a safe way.
Yeah. On that note, Sean, I've been asked to break up with people. So if that's going in the letter, then yeah, I think it's a good idea to have some do some planning around delivering that message.
Yeah, you're right. Sometimes we're the first line of communication about the separation, which it can be traumatizing. It can be difficult, but for some people, that's what they need, right? They just don't have the ability to express this to their partner, and sometimes we have to be that first line.
Yeah, for sure. Or their partner is, you know, it might be something more sinister, like they're really good at gaslighting and convincing, convincing me that this isn't what I want, and that
Yeah.
I'm just anxious and I need them, So I know I sort of framed it as a bit of a joke, but it is helpful to have that option
Yeah, absolutely.
through your lawyer.
Yeah, and by the way, to anybody who's watching this, if you do have any questions about what we're talking about, we will have a Q&A at the end of the hour to answer some of your questions. But feel free to hit that Q&A button that's down in the bottom of the Zoom link here, and that'll send questions directly to us that we can either answer while we're talking by typing, or we can verbally give you those requests. Try to stay away from the chat because sometimes we don't see it, but the Q&A button is the best one to open up the discussion. In terms of getting started, you really have a few options, and it really does depend on what issues, which we'll talk about, you might have on terms of like the process and next steps. And generally we kind of look at like 3 or 4 different baskets. There's a lot of things within those baskets to deal with, but those are going to be the issues, the main issues that you need to deal with. And then that's how we design the process moving forward. We usually talk about parenting as one. So if you have kids, who's making decisions for the kids? What's the parenting schedule going to look like in terms of the regular schedule and a holiday schedule? Things like Christmas and Easter, Thanksgiving, things like that. Then there's your child support piece, which also can be a spousal support piece, depending on, again, the circumstances. And then you really have your division of property, how we are going to split up your assets and kind of recognize certain debts that might be there as well. And again, there's a lot to it. The division of property piece is a very, very lengthy discussion. But the goal in a married relationship is to do what we call equalization, equalizing out your net worths for the length of the marriage, so you both walk away pretty much with the same net worth at that time. So simple example, you have 100, your partner has 50, you're going to give them $25 to both walk away with 75. It's not about the actual individual assets, but it's going to be the totality of your net worth and how we calculate that. Again, way more nuance to it. There's some exceptions. There's joint assets that we have to figure out as well, but that's kind of the premise of it. Now, obviously, with the decision making and parenting, that is going to always be about what's in the best interest of your child. Sometimes what you want and what's in your kid's best interest might not be the same. Sometimes they do align. And then child support and spousal support is really based on income, parenting plan, and kind of a lot of other factors, like what roles in terms of spousal support, what roles did the parents contribute during the relationship? Is there an income disparity? Is there a need? Did they do something that was of value but didn't get compensated for it? All those kind of issues will be there. So once we kind of identify those issues, we start to figure out, okay, what's the next step? Now, if there's any type of property or income issue alive there, right? So the division of property, spousal support, child support, you have to do financial disclosure. That's a really important thing to do. And what I mean by that, again, is you're starting to look at what your net worth was from your date of marriage and your date of separation and what's current. And then we're looking at your income that is historically over the last 3 years. It's a lot easier if you're a T4 employee. Your income is pretty basic. But if you start to have your own businesses, your own corporations, you have multiple revenue streams, rental properties, dividends from stocks, things like that, that's where that assessment can become a little bit more complicated. But that's why we do the financial disclosure piece on your income. So then we can start to figure out how we deal with support based on the parenting plan that you're going to decide about. When you do the division of assets piece, when we're talking about married spouses, we are, like I said, looking at your net worth. And so we look at, again, that date of marriage. Some people might not be able to get documents from 20, 30 years ago. That might be difficult to find. We try our best and we try to maybe make assumptions or presumptions on what those assets could look like, but we're really looking at significant assets at that time, right? So if someone had a house that they brought into the marriage, we really want to get documentation on that house. they had a large RRSP at that time. We want to try to get some documentation. If they had a, you know, a $2,000 checking account, we're less concerned about that. It's really about significant assets at that and debts at that date of marriage. So we can make sure that you're not necessarily starting from zero. You're getting credits, or you're getting, you're working uphill a little bit with respect to those debts and assets. And we do the same thing on your date of separation because we really want to calculate it. And the reason we do current is because we want to see maybe where money has gone in terms of bank accounts, things have started to move around. We want to see your cost of living. We want to see your budget. We want to see, again, that needs, and also to maybe show up some red flags that, hey, you had $50,000 in a TFSA and it's all the way down to 10,000. Where did that money go? And that really helps us kind of draw lines and figure out where things are going. To help you in those processes, we usually send out a checklist. It might be very overwhelming for you. You might say, well, I don't remember X, Y, and Z. And so we like to send out a really large checklist that says, hey, do you have a TFSA? Do you have an RRSP? Do you have a pension? Do you have real estate? Do you have this? Do you have that? Do you have life insurance? And that starts to get your mind, triggering about what you might have or might have had at that marriage date or at that date of separation date. We care a little bit less about what's kind of happened in the middle. We're really looking at those triggering dates. But there could be reasons that we start to request historical documentation to help kind of substantiate some of the values that you would have had at your date of separation. Now, if you have really interesting assets, like you have a business, right? Or you have a really impressive collection of stamps or coins or baseball cards, you might need to get those valued. We're not professionals in this. We can't simply say, okay, and you might be really well in tuned with what the value of that might be. But if you were ever to go to court, you're going to need expert advice or expert evidence to substantiate the values of those assets. Now, for a business, we use what we call a certified business valuator. They will usually come in, they'll look at your financial statements, they'll look at your ledgers, they'll look at your debts, they'll look at all maybe the shareholder agreements that are involved in that corporation, and they will assign a value based on net worth and maybe some goodwill to what the actual business might be. They'll also even look at what your income could be from a support perspective, because usually with the guidelines, the child support guidelines, there might be some additional income that we add on top of what you've reported to CRA. There could be some retained earnings. There could be some business expenses that were really personal, maybe a cell phone, a car, things like that we can gross up that income to really identify what you would have actually had from a support perspective. There's, obviously, certified appraisers for cars or for real estate or for things like that as well. So it's really helpful to retain those people because they offer up the best information to get a proper analysis and amount and value for those. So we're not necessarily arguing over it. It does really help out to hopefully streamline the process and get you you'll probably it's unlikely to have an unexpected turn if it gets professionally valued like that. Does that cost more? Absolutely. That is something you have to factor into the analysis. And so if your business really is not worth a lot, does it make sense to spend for a CBV that's going to cost like $5,000 to $20,000, give or take? So you have to weigh those out. And that's part of the discussion that we have with our clients, right? We say, okay, let's look at the disclosure initially, and let's think about whether there's merit to going and getting this appraised, or whether the lawyers can have a discussion about this and try to reach a consensus on the value of this asset or this debt without having to incur all these fees, because we know that generally can be a really large fear for people, right? They're going into this, they think that they're going to have to split up a lot of their assets. They're going to have to start paying support. We don't want to make them bankrupt by doing the process. We are trying to find a cost-effective way of doing that. And really the goal in all of this with the financial disclosure is it's kind of going to go hand in hand with moving the matter forward to start talking about maybe an interim parenting plan if you have children. The other side of it is, are there urgent issues, right? Has there a situation been present where there's a safety risk? And Ryan was talking about safety planning. Is there a child being withheld and you're not getting any parenting time? Is there no support? Did your ex take all the cash from the joint account and liquidate it and move it into their own specific account. And so you don't have any access to funds. There's no liquidity there. Those kind of urgent issues need to be dealt with at the onset as well, whether that's through having discussions with the lawyers so we can make it very obvious to them, whether it's thinking about an urgent application in the court with a motion to try to get some type of relief for you, whether again it's a non-depletion order, making sure that the bank account doesn't get depleted, whether it's a situation where there's an interim temporary parenting plan where they're guaranteeing that you're going to see your children. All those kind of things can be dealt with. On the other side, we always recommend not cutting off the other spouse, right? We want to try to keep this as status quo as you possibly can in the very short term until we can kind of figure things out. We don't want to escalate and increase conflict at the very beginning, because then you're working backwards and you're spending so much more time and money undoing the conflict that started. We always try to say to our clients, try to keep this as amicable as possible. Try to keep the status quo going initially, because we really don't want to start to increase the legal bill on certain things and then having to work backwards to undo them. It's really unfortunate when we see people spending tens of thousands of dollars without getting any movement whatsoever because someone made the decision to alter the status quo, and now you're dealing with undoing that damage and that harm, and then really getting back to the zero and the homeostasis there. So that's really kind of an important part there. And then as we're doing that, we have to think about what process we want to go through, right? So you start your financial disclosure. You really have to think about, well, do we want to do lawyer-led negotiations? Do we want to start thinking about mediation? Do we want to start thinking about maybe arbitration, mediation arbitration, which is kind of a hybrid that you start with mediation. And if you can't resolve things, the mediator takes off that hat and becomes your private judge as an arbitrator. There are a lot of options that you can think about depending on your interests, your goals, what's kind of happening in the interim as well, that we can have discussions about. And that doesn't mean that you start in one and you have to kind of follow that the whole way. There's a way to, you can pivot if that's not working. I have files, unfortunately, where we really want to try to be amicable and we want to try to mediate, but something happens and we have to shift to a court process, or we're in court and everybody really wants to resolve things. So we book a day of mediation and we try to resolve it out of the court process. It's a bit of a fluid dynamic, and we really do want to make sure that every option is available. And I think what's great about Ryan and I is that we're trained in kind of every area. We have people who do court in our office. We are both trained mediators. We can do arbitration. We are also collaboratively trained. And so we're able to offer up all of the options to all of our clients to ensure that it meets their needs and their goals as well. And really, like, the goal should be, again, to try to move this forward. When you get stuck in the mud, that's where things start to get bad. And that's when things take forever. And when you don't start with this forward momentum and not have a process designed, sometimes files can take years because of that. And really, our goal at our office is really to try to move things forward. We don't want you guys sitting around. We know it's your life. We know that you are really in a high stress situation. And the longer these files take, the longer that you guys are stuck in limbo without any finality and closure. And I find that the co-parenting relationship can't be repaired while you're still adversarial. And so while you're still negotiating things and while there's a lot of uncertainty, especially if you're living in the same home, you really can't work on that post-separation repair and that reestablishment of a relationship as a co-parent. So those are kind of like the most important things. The last thing you have to think about is whether you're coming into this as a common law spouse versus a married spouse. Things shift a little bit just in terms of your entitlement and your rights, but generally we try to do the process very similarly. The only thing that, the big difference is how you guys share and split your property. There's a presumption as common law spouses that you don't have an automatic entitlement to this equalization framework that's in the Family Law Act. And so we do have to talk about your situation a lot more to see if there are any other types of what we call equitable claims to try to advance. Now, the idea here is, thinking about, did someone contribute to an RSP for the other spouse? Did someone renovate the home that you're not on title with and you spent a lot of your money to do it? Did you pay down mortgages? Did you do certain things like that you didn't get value for? And are there these equitable claims that would be unfair for you to not advance if you just kind of walked away from the division of property like that? So those are kind of the initial questions that we need to start talking about when we get through the financial disclosure piece. And then there's going to be those follow-ups to ask you for additional financial disclosure statements or documents to substantiate those claims. And so we need to do that, and it goes hand in hand. But we like to basically have a double edge or a three-pronged approach here, where we start with the financial disclosure, but we also start to tackle the immediate, more pressing issues like parenting, like interim support, and making sure that we get that forward advancement. So we're not kind of just we're not just kind of spinning our wheels and not moving forward like that. So those are really important things that we should do at the onset. I'm not sure if Ryan has any more to add to that, because obviously he's got some other things that he might recommend, but he's also going to recommend what not to do in this scenario too.
Thanks, Sean. I think you covered a good amount of what not to do, but I've got a few more things to add. But I noticed there have been a couple questions about data separation.
Sure.
And I get this question all the time. Well, we still live together. Does that count as being separated? And the answer is you don't have to be physically separated. So living in different homes for you to be separated under the law. Okay. Sometimes it's the only option. Sometimes it's just the best option, right? Paying for two homes is very expensive all of a sudden. And sometimes it's just the best thing to do for the kids. We'll live in different bedrooms, we'll live in different parts of the house, or we'll cycle in and out of the house, something called a nesting arrangement. You're still living in the same household, but separately. You're more like roommates at that point. If you could do that for as long as you want. I mean, some people live together forever and they never get divorced and reconcile their relationship. They have relationships with other people. It could get a little bit complicated if you reconcile your relationship. If you basically nothing happens unless you separate again subsequently, in which case you might be having an argument about entitlements to some financial stuff. But essentially, you can live in the same house and still be separated. It's very, very common because it's often just really necessary. Okay. So in that vein, one of the things that we at least caution people to consider before doing is moving out of the house. A lot of the times it feels really important because we just can't stand to be in that environment anymore. Maybe it's not healthy for you or your spouse or the kids or everybody, and physical separation is important. There could be some consequences from a legal perspective, financial perspective, potentially. Okay. Sometimes people will argue that the spouse abandoned the home. And if it goes up in value afterwards, then they should not, participate in that. Or perhaps they also, will be alleged to have abandoned the children. And that establishes a new parenting arrangement where the parent who stayed home gets to be the primary parent or something like this. There are defenses to these things, but the point is now you've sort of gone into a messy potential situation where you're dealing with these arguments. So the advice would be don't move out without considering some of these implications and the risks. And if you're fine with them and you have to do it, well, we can't tell you to stay in an environment that's hostile or unhealthy. But ideally, we might, look at an interim agreement, which is like a short-term, temporary. Hey, we agree that it's best for everybody that we move out, and also here's how we're going to pay for stuff. Like, okay, you'll do the mortgage, I'll pay for my rent, we'll share the kids' costs. Basically, just stabilizing things for a little while maybe 6 to 12 months, while you negotiate a separation and a final separation agreement. You can always bring these financial issues back into it. But the point is, if we write an interim agreement that says you'll live in the house, I'll get an apartment, but we'll still share the, cost of the house and the increase or decrease in value of the house, then it's just not going to be an issue in the future. So much of what Sean and I do is planning around avoiding future conflict. Right? I mean, if people come to us, they're already in conflict, so let's resolve that. But also, while we're at it, let's reduce as many opportunities as we can for you to have more conflict in the future. So that's one of the ways that we might do that. Changing the locks. A lot of people say, "Well, can I change the locks? It's my house is in my name." Um, if you're married, there's a section of the Family Law Act that says, regardless of title, your matrimonial home, the non-titled spouse has certain rights to the matrimonial home. So they have possessory rights. That means they can come and go, even though their name's not on title. They also have rights to know if the house is being sold or mortgaged. So the continuation of don't change the locks is don't put a mortgage on the house all of a sudden after you separate to make it look like you have less money. And don't sell the house out from under your spouse. These things exist for good reason. I guess historically, some people would sell the house, take the money, run away. Now they can't do that because their spouse needs to sign off. So don't sell the house. Don't change the locks. Don't kick them out. Okay. Please don't take your kids anywhere without advance warning and ideally permission. Certainly not outside of the jurisdiction that we live in. Certainly to a different country. What we want to avoid is, yes, stress at the border of the country. Maybe they want to know where the other parent is and if the kids are permitted to be there. But even if you make your way into that country, the other spouse might call the authorities and accuse you of abducting the children. And if you've taken them without their knowledge or permission, if you've taken them contrary to, either an agreed upon parenting schedule or sort of a assumed or understood parenting schedule, and that could be the two of you living in the same house, trading off hour by hour, and all of a sudden the kids are in Florida or something like that. They could call the police and say, my children have been abducted. And if they're in a country like the United States, then you can get a court order here that the authorities in that country, in this case, the United States, would enforce. So the sheriff can show up at your condo in Florida and arrest you. It's not something you want to have to deal with. Okay. Sean sort of touched a little bit on the status quo. Financially is really what we are referring to there. So when we say maintain the status quo, it's like don't cut off people's credit cards, don't close down people's lines of credits, close down people's access to money, don't drain the line of credit, don't liquidate all the investments, don't make these major changes. Just keep paying for things that the way you have been. Until you can have a discussion about how to pay for things, either in the interim or during the sort of temporary period while we figure stuff out, or at the end when you have a final agreement on how things are going to work permanently. Okay. This avoids a few things. It avoids people freaking out, getting scared, conflict. Okay. It also avoids, as Sean was alluding to, urgent court issues. If I can't buy groceries because I don't work and I have a credit card that my spouse paid for, but they cut off the credit card, I can't feed my kids, can't pay my rent. I have no choice but to hire a lawyer to go to court right away, like tomorrow, to get me immediate access to support and funding. Right? So ideally, you're having a conversation about how to fund, your lives moving forward. We get that life is different. You can't necessarily stay in the same house or in the relationship. It only takes one person to end a relationship. I see there's a question about that. So when we say status quo, we don't mean staying in the relationship. We're talking about sort of maintaining the financial arrangement. Okay. don't quit your job because you think that it's going to get you out of paying support. If you voluntarily leave your job, um, you're going to be deemed to have, you're going to have income imputed to you, which means essentially the government's saying, we can't force you to work, but you do have an obligation to, support your kids and or your spouse. So we're going to treat you as though you're still earning that income. So if I made $100,000 and I was like, screw it, I'm quitting. That way I won't have to pay support. It's the exact opposite of that. I'm going to have to pay support based on earning $100,000, but now I don't have the $100,000, right? So that's not a great thing to do. Okay. And then finally, and I know this is a tall order, it's a big ask, but if the temperature, if the communication dynamic with your spouse is not great, what not to do is engage with them beyond what is necessary. Okay. It's hard because we all have triggers and buttons, and more than likely our spouse created those triggers and buttons. They're the person we've been with the longest, on top of our parents and everything. But so it's very easy for those buttons and triggers to get pushed. So to the extent that is possible, engaging in a little bit of emotional regulation work, whatever that is for you, if that's mindfulness, if that's therapy, just anything that puts 5 seconds between the trigger and your response. So when I say trigger, I mean they sent you an email saying you never looked after the kids, and your response being you're a terrible person, something like that. If you take 5 seconds, breathe, notice that you're having a reaction, you can then be intentional about how you respond. And in that case, my advice is just don't respond to that. I mean, that's just goading you into a conflict. But let's say you're exchanging emails about the parenting schedule, and the email says 3 things. I can only do Friday from 12 to 8. You're a piece of crap, and I hate your family. The response, I would say that you should focus on writing. It would be to follow the BIFF method. BIFF, brief, informative, friendly, and firm. Brief, say no more than necessary. Informative, stick only to the facts. Friendly, don't go into the weeds with them. Firm, no room for negotiation. So my response would be, thanks for your email. See you Friday at 12. This will ideally cut down on the back and forth, save you some emotional and bandwidth. Okay. And it also means you have to call your lawyer less often to say they're being, this person is being unreasonable. What do I do? And that's going to save you, however many dollars an hour. Okay. So those are my sort of hot takes on what not to do. There's a lot more to that depending on the situation, and sometimes these things are difficult. So let us know if you have any questions on those pieces.
We've got a bunch of questions in the chat too that we could turn to. There's one here just in terms of how can we maintain the status quo with a self-employed spouse wants to move out and separate? And I think we did touch upon that in the majority in this terms of status quo should try to be financially. And if there's going to be 2 separate homes, that is something you're going to have to figure out in terms of parenting schedules and how to deal with that. But there is maybe an obligation there to continue to pay for certain bills, and maybe it's in lieu of a certain amount of support to help with the mortgage on the house or to help with property taxes or anything like that. Circumstances are very unique. It's going to be hard for us to give you proper advice on this without knowing incomes and assets and things like that. But really in the short term, there should be a goal to try to keep everything as stable as possible, even if you are living under 2 separate roofs, until you can come to some type of financial arrangement that will work for the both of you, or again, something that's been negotiated between lawyers to then effectively start to separate your finances. But the reality is you need to have that separation of finances once you have a full understanding of all the factors that could be at play, and having a conscious decision on budgets and expenses and how things are going to work like that. That can happen overnight. It's going to take some time before everybody can really have a good picture, especially if one of the partners really didn't have a good idea of what those monthly expenses look like, or who, or whether they took care of it or not. It is going to take some time to find that out, and really get to the bottom of what your month to month budget's going to look like.
Yeah. I completely agree. And there's another question about money being moved out of a home equity line of credit and potentially being hidden in cryptocurrency. And then, what do I do? I'm going to give you the annoying lawyer answer, and then I'll give you an actual bit more of an answer. Um, Go talk to somebody, talk to a lawyer, talk to an accountant right away. Um, you got to get specific advice on your situation, um, because once money disappears into, the internet, like it can be gone. So get some advice as soon as possible on any steps you can take to sort of mitigate or cut down on any future actions like that. Um, the answer that I would give for real is it depends on it depends on the situation. I mean, have you separated? If you have, and that money came out of the home equity line of credit after the date of separation, then there's an obligation that he repay that, or they repay that, um, either directly onto the line of credit or back to you, directly. And there would be a record of these things, right? You'd have the statement from the month. Let's say it's January 2026. There'd be X amount of dollars leaving the HELOC into, how much line of credit into an account. That's held by one of you, right? You took joint assets for a sole purpose. You got to pay that back. No argument there. If you're still together, you haven't separated, your argument gets a little bit, your situation gets a little bit messier. I still suggest you get advice and into what records you need to start keeping, okay, to prove that this was done in contemplation of separation, so that you can advance the claims for repayment that you'd be entitled to. If he's taking it from the joint line of credit and put it into an investment account, and then that investment account is subsequently shared with you, I mean, you're still it hasn't disappeared. You're saving, you're sharing in the same amounts. But if that money is hidden, if it's gambled away or hidden, then it gets a little messy trying to claim that back. So you need to have those records in place. So I would start on that right away.
We have another question essentially about saying that someone works part-time, excuse me, running an Airbnb in their property, and they're thinking of pausing it, so not earning any more income on it, but living there as a separate residence, and how that would affect maybe the splitting of assets. Those are kind of two different things where, yes, you might be losing some of your income, which is important because, if that's funding your life and your livelihood, we don't want to recommend that, but maybe there's an opportunity to find additional work outside of that Airbnb that can augment or substitute that amount. But stopping and moving in there, if the asset was in existence during the marriage, it's still an asset to be split. If you're living there after the fact, after separation, it doesn't negate the fact that there could still be a division of assets depending on who's on title, what that equalization payment is going to look like. Those are kind of two baskets that we're looking at that are very different. The reality will be that your shelter is probably the priority and a more important thing, but you're going to have to then go talk to someone about this to weigh the pros and cons of doing one way or the other, whether stopping that and not having an income and moving in there is a better option than continuing it. That is a very personal situation that you're going to have to talk to potentially like a lawyer to understand the pros and cons of doing both.
Sure. There's another question about what happens to assets that are purchased after the date of separation, and what can be done about those assets that have been purchased, or are someone's maybe thinking about purchasing. Favorite cop-out lawyer answer: it depends. Right? Where did the money come from for the purchase? Right. So if I separate on July 1st, or sorry, on January 1st, 2026, that's my date of separation. That's the date that I'm sharing all my assets, the value of all my assets with my spouse. Let's pretend I've got $10,000 in a TFSA. That's all I have. Not too far off the truth, actually. So, and then on January 15th, I go and buy a $5,000 snowmobile, right? Um, as of the date of separation, I had 10,000 bucks. That's there. That's fixed. That's not going anywhere in my bank account. My TFSA statement is going to show that. So I'm equalizing that with my spouse anyway. If they have $0 at that date and I had 10,000, I got to pay them $5,000, so half the TFSA, whether I still have it or not. I put whatever into a snowmobile, or maybe I spent it, drained it. I still owe them $10,000, right? So if I took money from assets that I have to share or equalize with my spouse anyway, doesn't really matter, okay? Because they're getting paid for that. Okay. If money's coming from, comes in after the fact, it could be irrelevant, right? Like if my parents gave me $10,000 on January 15th and I decided to spend that on a snowmobile, that's my prerogative. We're separated and that money has nothing to do with our marriage. It wouldn't be included in my net family property. Okay, so my spouse would have no say over what happened to that asset. The third scenario that I can think of is, well, what happens if, let's say I took money from joint funds? So sort of coming back to that line of credit example, let's say I took 50,000 bucks out of a joint line of credit and I bought a new car. I have to repay my half. Okay, or I took it out of a joint bank account or something like that. So I'm gonna have to I either put 50,000 back into the account, which would then be divided in two, so 25 each, or I have to pay my spouse 25,000 bucks. Okay, so it really depends on the timing and where the money came from. Okay, tough to mitigate because again we sort of don't have control over what our spouses do, but you do have the rights to a lot of the financial disclosure to see where money is gone and where it's going, and that's why your lawyers and financial experts would look through these statements to make sure it's all accounted for, basically, so that you're not shortchanged.
Mhm. There's another great question about how we calculate income for child and spousal support. This person's basically their income fluctuates every year, or fluctuates, and it could be up one year, down another year. To try to keep it as brief as possible, there are the child support guidelines and then the spousal support advisory guidelines. The child support guidelines are basically like what dictates how we calculate income for both. And then there's a few other factors in the guidelines for spousal support as well. But generally, you do start with your line 15,000 income on your tax return. And what that is just your total income for the year that you've reported to CRA. That's kind of what you start as. And then there are exceptions to that afterwards. And so a great example like this would be if there was a fluctuation of income, a court could say, we'd rather take an average of your last 3 years' incomes to come up with a better cash flow analysis for what you actually could pay per year. There's also undue hardship claims. There's a whole lot of other things that you can do, but really the starting point is that last year's 15,000 income, or what your current income is. If your income could be different this year comparatively to last year, the legislation really does say current income. Most lawyers will use that 15,000 from the year before to kind of give you a nice benchmark to adjust and quantify it right there. So there's less negotiation with it. But I do have a lot of people that have cash flow issues because of that. Sometimes I always say, well, you're just going to play catch up the next year, because if your income fluctuates, you might be high this year, but you might be low next year. And maybe sometimes that balances out year over year. But there are other ways to adjust it that we could go into when we're talking about it. If again, this cash flow issue is presenting itself over and over again. Yeah, I mean, I want to keep it brief. So
Okay, so we got 5 minutes left and a bunch of questions. So I'm gonna speed answer two or three, and then I'll have Sean do the same, and then we'll
yeah,
sign off. What are the steps after financial disclosure exchange? Um, my recommended next step would be to have your lawyer prepare some calculations for you. Okay, based on the financial disclosure, they'll tell you about entitlements and obligations, and then they'll tell you about options for how to go about negotiating a resolution. So if it's me, we're sitting down, we're reviewing the documents, I'm explaining the law, I'm getting a sense of what you want, your outcomes, and then I'm saying, okay, well, let me call the other lawyer. We'll sit down, or maybe the four of us hop on Zoom and figure it out, or let's just write something. Maybe it's simple. Hey, I'll give you 10,000 bucks. Have a good one. It depends on the situation. The short answer is you negotiate a resolution, you write up the separation agreement. Okay. Speaking about separation agreements, should it be made before moving out when you don't have minor children? Um, Ideally, because then you can avoid, arguments about, abandonment of the home, but that might be a pretty low risk situation for you. So maybe you just need to move out because like I said, there are no kids. You can do that, if you want, you need, but again, just maybe chat with a lawyer quickly to make sure that your situation, isn't, you're not getting yourself into a rough situation. How do you prevent your spouse from drawing down accounts? Well, again, it depends what we're talking about. If it's after separation, they can do whatever they want. They've got to share with you what they had at the time anyway. If it's before you've separated, it's very, very difficult to take action against the spouse you're currently with, right? So you got to talk to them and take whatever steps you can, maybe redirecting your paycheck, or dividing up your investments or something like that, so that your spouse doesn't have the ability to do that. Okay. Um, Next up, at what step does the financial negotiation occur? So that's after the exchange of financial disclosure. You can't assess your legal rights unless you know what's on paper, right? And then you can make offers and deals from there. Sean, speed round.
yeah. What happens if a partner had a startup that wasn't worth anything and it's grown on paper, but it's not really profitable, but the value is high, salary is low? The short answer: get a certified business valuator in to assess the actual value of it. It's there's probably some goodwill and some and worth there, and there could be some asset value to it if there's no salary. But again, that's going to depend on the circumstances when we look at kind of the file and the financial disclosure that comes with it. Um, is it better to take, if you're going to pay off some debt, is it better or worse to pay it off from a loan before the date of separation and after? I mean, that depends on circumstances also. I love to say that, but listen, if you're about on the verge of bankruptcy or your house is about to be foreclosed on or anything like that, you got to pay it off. Like that's just the reality of it. On a negotiation tactic side of things, debt on your balance sheet from a data separation perspective does reduce your net family property. So that sometimes happens, but there's a lot of wishy-washy stuff associated with that I
Don't
wouldn't recommend. Yeah.
try to avoid a situation where you're arguing over whether it was a loan or a gift. So
Yeah.
I would wait,
Yeah.
personally, unless you absolutely have to pay it off.
Yeah. And then what happens to any funds in your personal retired savings account or plan, registered savings plan after the date of separation? If there's no spousal contribution during the marriage, is it an individual? So your accounts that are solely in your name will always be in your name. You take them. We're really just looking at the net worth to equalize. That's really what we're looking at in terms of the value. It's not anybody else's account. You can pay an equalization payment by using an RRSP or maybe some type of pension as a rollover to that other person if there's going to be a difference, right? If there's more money in that account, and that's really the only source of funds that you have to satisfy that equalization. But we're never taking sole assets from that person. Ownership is yours. It's always going to be yours. We're really looking at the value of those accounts when we're assessing who's paying who in equalization.
Okay,
You want to take the last one?
last
Yeah.
question, then we got to sign off because it's one
Yeah.
o'clock. What about an inheritance? Okay, I've got an inheritance, but my spouse hasn't prepared for retirement. Can they try to claim a part of the inheritance? Um, It depends, right? If you've kept that inheritance in a separate account, it hasn't been mixed into joint account, joint funds into the house. That's an excluded asset, most likely, as long as again you can prove it was an inheritance. So the asset itself, you wouldn't be able to touch. It is relevant for determining, your need to spousal support, though, right? If you've got $1 million in an investment account and it makes you $50,000 a year, well, you've got $50,000 a year that person doesn't. And if they make $50,000 a year employment income, there's no difference in your income. So they're not going to owe you um, uh, spousal support, even though your income comes from an excluded asset. It's still relevant to determining your need. And then it is also going to depend on the other person's ability to pay. So they can't claim it, but the income from it is certainly relevant to determining how much support you would be entitled to, okay, and your ability to be financially independent. Okay. So that's the last question. So anything else that comes in, I'm unfortunately going to have to ask you to reach out to us by email, and we can send you a response. I just wanted to say thank you so much for everybody that attended. Thank you for your questions. This is a really enjoyable conversation for me. I'm going to assume it was at least tolerable for Sean. And yeah, please, we hope that this provided just a tiny bit of clarity on what next steps could look like, because it's an unknown time, right? A lot of people describe feeling very much in limbo during this time, but having a sense at least of how long things could take and where to go, we find is helpful. So we really hope we provided that. And please reach out if you have any questions. You can schedule a consultation with us or any of our other lawyers or professionals. We'd love to hear from you. Thank you again. Have a great day.
And I will say, last thing before we go, just as an FYI, we will be sending out a recording by email. So if you ever want to revisit this again, it will be in your inbox in the next couple of days, and it'll also have all of our contact information. Bye for now.
Thanks, Sean.
Take care.